Welcome to Employment Law class. Today we look at Section 4 of Unit 3, which is on employment and termination of employment of certain group of people. Session objectives. By the end of this session, you should be able to identify the laws that pertain to the employment of certain categories of people. Also, explain what accounts for a fair or unfair termination of employment. Persons with disability. Now, Section 59 of the Person with Disability Act 2006 Act 715 states as follows: an individual with physical, mental, or sensory impairment, including visual, hearing, or speech functional disability, which gives rise to physical, cultural, or social barriers that substantially limit one or more of the major life activities of that individual. So this session tries to define who a person with disability is. So the Act gives this definition of someone with disability. It could be physical, it could be mental, it could be sensory impairment, it could be hearing. Any of these elements that we have mentioned, if the person is suffering from any of them, then you could say that the person he or she is a person with disability. An employer is required to notify the nearest employment center attached to disability unit of the employment of any person with disability. So, as an employer, you have a duty to notify this particular disability unit center if it is near to you that you have employed such person. That is your duty as an employer. In the Labor Act, special incentives are provided for employer who employs persons with disabilities. So the Labor Act gives special incentives for employing disability. So you get an incentive for employing someone with disability as defined in the previous slide. Disabled persons who engage in business or enterprise are also entitled to incentives. So if you engage in such business, or if you engage in business, you are entitled to an incentive. So under the Income Tax Act, a disabled person is entitled to 25% tax relief from his or her assessable income. Assessable income simply means all the income from business, from employment, and from investment. The disabled person will be entitled to a relief of 25%. So what happens if a person is employed and he's disabled in the course of the employment? Employment not ceased upon disablement. Now we are saying that the employer must consider if he or she can fit that another corresponding job. So if someone in your organization or your company suffers some injury and the person becomes disabled, your first duty is to consider whether the person will fit for another job in the same organization, whether there's a corresponding job for the person. If no corresponding job can be found, the disabled worker may be terminated by notice. So if you don't find any corresponding work, then you give notice before you terminate the appointment. In all cases of termination, the notice shall not be shorter than 1 month, even though you will terminate it, but it should not be less than 1 month. A person with disability may be transferred to another job within the same establishment if the other job is a corresponding job. So you can be transferred to another job in the same business if you possess the skills to do so. Employment of women. Section 55 of Act 651 provides the following: unless with her consent, an employer shall not assign or employ a pregnant woman worker to do any night work between, so the emphasis on night work, between the hours of 10 o'clock in the evening and 7 o'clock in the morning. So you cannot assign or employ a pregnant woman to do any night work between the hours of 10 o'clock in the evening and 7 o'clock in the morning. Before you can do that, the worker, which is a female, must give consent to that, or engage the person for overtime, a pregnant woman worker or mother of a child of less than 8 months old. So when it comes to a pregnant woman or someone who has given birth to a child of less than 8 months, you cannot ask the person to do overtime. Before you do so, the person must agree, give consent. So consent is key. An employer shall not assign, whether permanently or temporary, a pregnant woman worker to a post outside her place of residence after the completion of 4 months of pregnancy, if the assignment in the opinion of a medical practitioner or midwife is detrimental to her health. Here, what it simply means that if a woman becomes pregnant and the pregnancy is for 4th month, then as an employer, you can't send the person to different place or move the person from his original residence, especially if a medical practitioner has given advice that doing so will go against her health. Still on employment of women, maternity leave, annual leave, and sick leave is captured under Section 57 of Act 651. It provides that a woman worker on production of medical certificates issued by a medical practitioner or midwife indicating the expected date of her confinement is entitled to a period of maternity leave of at least 12 weeks, in addition to any other period of annual leave she is entitled after her period of confinement. So the key requirement here is that the person should be satisfied by medical practitioner. There should be a certificate. So you don't just go and say it's all right. The woman must produce a certificate, and that certificate should be issued by a medical practitioner or a midwife. Once that is produced, she will be entitled to maternity leave of at least 12 weeks. So the minimum weeks will be 12 weeks. And this is not the only one. If there's any additional period for annual leave, it will also be added. So minimum leave for the maternity will be 12 weeks. So it means that you can give more. A woman worker on maternity leave is entitled to be paid her full remuneration. Note, don't say that because she is on maternity leave, you are going to give her half. It is against the law. Full remuneration. If she is taking 1,000 Ghana cedis or 20,000 Ghana cedis, you give the whole amount to her, and any other benefit. So other benefit too, you give it out. That's the law. Whether you like it or you don't like, that is the law. Allow the woman to enjoy. The period of maternity leave may be extended for at least 2 additional weeks. So the maternity leave of at least 12 weeks could also be extended for at least additional 2 weeks where the confinement is abnormal, or where in the course of the same confinement 2 or more babies are born. So if 2 or more babies are born, then you will get additional 2 weeks. You should also know that a nursing mother is entitled to interrupt her work for an hour during her working hours to nurse her baby. So if you're a nursing mother and you go to work, the law allows you to take 1 hour to go and take care or nurse your baby. You should know that this 1 hour is separate from the break time that the worker is entitled to. An employer shall not dismiss a woman worker because of her absence from work due to. An employer shall not dismiss a woman worker because of her absence from work on. So here is on, there's a missing figure, on maternity leave. So the fact that a woman is on maternity leave does not give the employer the right to dismiss. When you dismiss such a person, it's an unlawful dismissal, and you face the law. Let's now consider employment of young person. A young person shall not be engaged in any of the type of employment or work likely to expose the person to physical or moral hazard. So you cannot engage a young person in this regard. A typical example would be galamsey. You don't have to engage young people in galamsey. An employer shall not employ a young person in an underground mining. So as I was saying, galamsey totally prohibited. An employer shall not employ a young person on any work unless medical practitioner has satisfied that the young person is in good health and is medically fit for the work. So before you can employ a young person, a medical practitioner should satisfy that indeed the person has the strength to do that work. Termination of employment. So section 15 of Act 651 provide grounds for termination of an employment. So when on the grounds of sickness or accident, you can terminate the employer can terminate the person's employment or appointment. If the worker is incompetent, the person doesn't have the required skills to meet the current demand, the contract can be terminated. Proving misconduct. If consistency, the worker has engaged in gross misconduct, it can be terminated. While there's mutual agreement between the employer and the worker, this one is a cool deal. Maybe you want to move to different place, or you want to travel out of the country, or you want to just cease to work for the employer. By agreement, you terminate the employment. So the worker on grounds of ill treatment or sexual harassment. If you're a worker and your employer doesn't give you treatment, you can terminate the employment. It's by law and the law accepts. If your employer is engaging you in sexual harassment, you can, based on that ground, to terminate the employment. By the employer on the death of the worker before the expiration of the period of employment. So death brings an end to everything. Once death occurs, everything has come to an end in terms of the person who has died. By the employer, if the worker is found on medical examination to be unfit for employment, so after falling sick, if medical report shows that you can no longer work at that particular field, then it's a ground for the employer to terminate that appointment. So you want to deal with the doctrine of notice. Here what you are saying is that in the case of a contract of 3 years or more, 1 month notice should be given. If you don't give 1 month notice, you give 1 month pay. So if the contract is 3 years or more, before you can terminate, you give 1 month notice. If you don't give 1 month notice, you give 1 month pay to substitute the notice. In case of contract less than 3 years, if the contract is less than 3 years, you give the person 2 weeks notice, or you decide to give the person 2 months, 2 weeks pay. Another option is that in the case of contract from week to week or 7 days, week to week, you have to give 7 days notice. A contract of employment terminable at will may be terminated at a close of any of the day without notice. So if the contract has that means you do it every day. You do it and you take your pay. That one you don't need any notice. Remember, if it's a contract from week to week, that one there's no option for pay. You may say you have to give 1 week notice. So section 18 provides that the employer shall pay to the worker any remuneration earned. So if you want to terminate the person's appointment, any remuneration earned, deferred pay, if you are deferred some of his or her pay, you have to pay. Compensation due to him as a result of the sickness or accident. In the case of foreign contract, expenses necessary for the journey and operation, expenses for the worker and accompanying member of the family in addition to any of the payments stated above if due. So what basically this provision is saying that, look, if you are terminating the person's employment, any amount you are owing the person, pay any amount that the person is entitled to pay before you terminate the person's appointment. The payment shall be effected before the expiration of the date of the notice period and where no notice is required by the close of the next working day after the termination. So as I said, you pay before the period for termination come into effect. We now want to deal with fair termination of employment. Section 62 of Act 651 deals with fair termination. Termination will be fair if the worker is incompetent. So if the worker is incompetent and you terminate, it is fair, no problem. Or the person lacks qualification in relation to the work, you lack qualification. That one too, if you terminate, it is perfect. By proving misconduct of the worker consistently puts up a behavior that is inconsistent with the policies of the company, termination is allowed. Redundancy under Section 65 is perfect. Due to legal restriction imposed on the worker, prohibiting the worker from performing the work for which he or she is employed, when court gives order or restriction, you have to comply. In that regard, termination will be considered as fair. Now let's deal with unfair termination of employment. A worker's employment is terminated unfair if the only reason for termination is so if because the person has joined or has intended to join or seems to be a member of a trade union or intend to take part in the activity of a trade union and you terminate that employment, then it is unfair. The person can bring action against you because under the Constitution, each person has a right to join any trade union of his choice. So if the fact that the person is going to join a trade union or has joined a trade union or participated in a trade union, you want to terminate his appointment, is against the law and it is unfair. That the worker seek office as or is acting or has acted in the capacity of or workers representative. So if because the person is working as a representative for a worker or seeking an office, you are going to terminate his employment, that one too is unfair. that the worker has filed a complaint or participated in proceedings against the employer involving in alleged violation of this act or any other enactment. Good. As I told you that if the employer gives you instruction to commit unlawful acts, you can decide not to carry on that act. Or if you have filed complaint against your employer and because of that matter, the employer has terminated your employment, then it's unfair termination. You can bring legal action against the employer. If you also try to terminate on grounds of gender, color, ethnicity, origin, social, political, or economic status, those grounds too, it will be illegal or unlawful. In the case of a woman worker, due to the pregnancy of the worker or the absence of the worker from work during maternity. So if the person has gone for maternity, or if the woman has gone for maternity, or the woman is pregnant, and because of that you have terminated the employment, it's unlawful. In the case of a worker with disability, due to the worker disability, this one too is not. You can't do that. It's unfair. That the worker is temporarily ill or injured, and this is certified by a recognized medical practitioner. So with this one, it should be satisfied, and it should be temporary, not permanent. That one too, if you sack the person, it is unlawful. So the remedies available for unlawful termination are reinstatement. So you reinstate, the court will give an order for reinstatement from the date of the termination of the employment. You also have re-employment, either in the work for which the worker was employed before the termination, or any other reasonable, suitable work on the same terms and conditions. So you can re-employ the person in the same work that he was doing, or different work on the same terms. You could also be asked to compensate the worker, that you pay all the amount that he would have been entitled if you had not terminated the employment. Now, issue of redundancy and section 65. It provides that when an employer contemplates the introduction of major changes in production, organization, so you are dealing with changes in production, organization, or technology of an undertaking that are likely to entail termination of employment of worker in the undertaking, the employer shall. So if there's going to be change in production or technology or organization, and we are going to terminate some people's employment, it is allowed, but you have to follow certain procedure. That provide in writing to the chief labor officer. So the chief labor officer must be aware. You have to put him on notice. And the trade union concerned, the trade union must also be notified. Not later than 3 months. So before 3 months the incident takes place, you have to do so. All relevant information contained and the reason for the termination, you have to give reason. Why are you terminating it? Because you give a reason, maybe you want to merge with other firm, or you want to expand the organization. The number and the category of workers. So which category of workers are affected by this redundancy, you state, or likely to be affected. The period within which any termination is to be carried out, you have to indicate that one as well. You also have to consult the trade union concerned. If they are part of a particular trade union, you have to consult them and show the measures that you have taken to minimize the termination, as well as measures to mitigate the adverse effect, because if redundancy occurs, people are going to suffer. So you have to take measures to reduce the effects. Is there any alternate employment for the employees? You have to also find out. So where an undertaking is closed down or undergoes an arrangement, so undergoes an arrangement or amalgamation, as I indicated previously, and the closed down arrangement causes severance on the relationship of the worker and employer as it existed immediately before the close down, arrangement, and amalgamation. So if it will cause a severe or if it will bring hardship on the relationship that exists between the worker and employer. B. As a result of an addition to the severance that worker becomes unemployed, so you are going to be suffered. The person will be unemployed, suffer any diminution in the terms and conditions of employment. If all these things exist, then the worker is entitled to be paid by the undertaking act which that worker was immediately employed prior to the close down, arrangement, or amalgamation. A compensation. So before this thing happened, the person might be compensated. That's what you call redundancy pay. So the person will be entitled to redundancy pay once he's going to suffer as a result of the amalgamation or the redundancy exercise. By way of summary, this session we dealt with the details and the laws involved in the employment of certain group of people. It's further explained what will account for termination of employment and the notice to be given. Issues were raised on fair and unfair termination of employment. And lastly, discuss issues on redundancy. Thank you and have a nice day.